Before concluding our analytical discussion of the preamble of the Constitution of India, it would be wise on our part to discuss and to analyze the very precedents in the form of ratio decidendi and obiter dicta as it was established by our Supreme Court in various important leading cases as they pronounced the very preamble of the Constitution as the basic structure of the Constitution. So, regarding that, we would like to discuss the first important leading case which declared preamble as the basic structure of the Constitution, which could not be easily altered or changed by the Parliament of India, as because according to their lordship, the Parliament of India has not that constituent power to amend under Article 368 relating to the very provisions of Article 13, which deals with law and which declares what is law in relation to the Indian Union and the Constitution of India. So, in very Keshavanand of Bharati versus State of Kerala in 1973, Supreme Court framed the very basic structure of the Constitution and it was carried out by their lordship in the next important leading case, and that is Indira Nehru Gandhi versus Raj Narayan in 1975, and also in A.D.M. Jabalpur versus Shivakant Shukla in 1976. So also another most important leading case, that is Minerva Mills Limited versus Union of India in 1980. The very ratio decidendi or obiter dicta as precedent, the Supreme Court laid down that the objectives specified in the preamble contain the basic structure of our Constitution, which cannot be amended in exercise of the power under Article 368 of the Constitution by the Union Parliament or the Union Government. So also in another important leading case of 2005, that is P.A. Inamdar versus State of Maharashtra, the Supreme Court in 2005 made the observation, it is well accepted by thinkers, philosophers, and academicians that the golden goals set out in the preamble are to be achieved. The Indian polity has to be educated and educated with excellency. So also, in another important leading case, that I.R.Coelho versus State of Tamil Nadu in 2007, Supreme Court expressed that preamble is controlled constitution and it was not framed by Parliament. So from this ratio decidendi and obiter dicta as were established by those above highly important leading cases decided by our Supreme Court, we have to examine those which are the basic structure of the Constitution. So, if preamble is a basic structure of the constitution, so also the very judicial review, the democratic republic, the sovereignty, the secular aspects of the constitution, the socialistic aspects of the constitution, so also the very relation between union and center. So all this falls under the basic structure of the constitution. So by analyzing the very preamble from its basic ideals that laid down in the form of democratic republic, sovereign, secular, and socialistic ideals, so also the justice concept relating to socio-economic political justice, the concept relating to liberty of thought and expression, belief, faith, and worship, and equality of status and opportunity, and fraternity or the dignity of the individual, and the unity and integrity of India, we would found the very observation of the Supreme Court as really important, as because these ideals are embodied in our constitution in different parts, such as Part 3 of the Constitution, which consists all the important fundamental rights, even Article 32, which relates to constitutional remedies or judicial remedy, which is itself is a fundamental right. So also the very powers and functions of the Supreme Court and High Courts, and also the president and its republican character of the union, and also the democratic elements of India's union, and the very distribution and separation of power that we found as regarding distribution of power in between the center and state on the basis of union list, state list, concurrent list, and the very separation of power among the legislature, executive, and judiciary. So, all these ideals we found are part of the very goals of preamble set out to be achieved by our founding fathers. So, the very observation that Indian polity has to be educated, and educated with excellency, as it was observed by our Supreme Court in 2007, is the most important direction given to state to educate every Indian citizen and every Indian people to realize those goals set out in the preamble, and that education must be in the form of excellency. That means the quality education must be guaranteed and provided by the state, that this golden goal set out in the preamble must be achieved. And so also, as it was observed in the last leading case in I.R.Coelho versus State of Tamil Nadu, it was observed that preamble is controlled constitution, as exactly it reflects that what the constitution contains, that is preamble. So preamble is otherwise could be called as controlled constitution, and as it was framed by the original constituent assembly, So it could not be any way changed or amended by our parliament, even if it has the power to amend the constitution under article 368, but it could not be considered as a constituent power of amending any provision of the constitution which were done by the original Constituent Assembly of India, which framed the very constitution which was adopted on 26 November 1949 and came into effect on 26 January 1950. So we have completed preamble with its very ratio decidendi and obiter dicta as precedent established by our apex court of the Supreme Court in the above important leading cases, and the very origin of the idea of basic structure of the constitution could be credited to their lordship in their decision on I.Keshavanand Bharati versus State of Kerala in 1973, and which was followed subsequently in the important leading case Indira Nehru Gandhi versus Raj Narayan in 1975, so also in the leading case A.D.M. Jabalpur versus Shivakant Shukla in 1976, and another most important leading case that was Minerva Mills Limited versus Union of India in 1980, and as it was carried on till now as for the decision of P.A.Inamdar versus State of Maharashtra in 2005, and lastly the leading case I.R.Coelho versus State of Tamil Nadu in 2007. So by this we completed the preamble of the Constitution of India, and in our next upcoming video we would like to discuss the very fundamental rights as provided in part 3 of the Constitution of India, which starts from Article 12 and up to Article 35 of the Constitution, which deals with the fundamental rights, and regarding that we would like to discuss certain most important fundamental rights in our upcoming videos.